So Aaron Perrin, who is the publisher of Family Ties, which is a periodical newsletter about family businesses, said that family businesses are accidental partnerships, which is a powerful and bizarre family ownership phenomenon that arises due to circumstances and not choice. He says that you do not choose these partners as fellow contributors to a business, but rather you inherit them from the lucky gene club along with family history and relationships. Now, any relationship between two or more persons has the potential for conflict, and relationships among family members adds a new dimension for conflict. I don't have Friday night or Sunday night dinner with my law partners here, but if I were in business with my brother, we would probably be having dinner at my parents' house on Sunday evening, and I think that's a pretty significant difference between a family business and a non-family business. So for a shareholder agreement to work in a family business, each member's needs have to be dealt with, and that usually requires some compromise from all parties. And given this backdrop, how can a shareholder agreement help the business and the relatives of the shareholders? One of the first things that I want to address is the issue of conflict of interest. I have to say that the shareholders agreement is an agreement among parties whose interests are potentially conflicting, even though they may not conflict at the time that they sign the agreement or they enter into business together. No lawyer can prepare an agreement that's going to adequately treat all parties to the agreement fairly and evenly, so the first question needs to be, who does the lawyer represent? Our rules of professional conflict do not allow us to represent both sides without proper disclosure. And even if there's adequate disclosure, we can't continue to act where there's likely to be a conflict of interest. Several years ago, I was involved with two sisters who clearly did not see eye to eye on many business issues. I acted for the company, so I did the first draft based on discussions with the sisters. They each got independent legal advice, and the final agreement was somewhat different than the original draft after two separate lawyers got their hands on it. So each sister had an advocate who was representing them, and some changes were made to deal with their various positions and interests. So independent legal advice may actually be necessary, but you do have to remember the added costs. On your screen is a statistic from the KPMG Australia Family Business Survey, which provides that only 44% of all conflicts caused, rather over 31% of those situations where there were conflicts, there was no mechanism in place to resolve the family dispute. So why have a shareholders agreement in the first place? Well, I think the importance really is in structuring it so that there is a dispute resolution mechanism aside from the courts. So just to sort of recap as to why have an agreement, well, it helps the business. It has the ability to help the relatives of the shareholders and understand what their roles may be. However, each family member has to be dealt with and their issues be dealt with, and there's going to need to be some compromise and potentially independent legal advice may be necessary. So overall responsibility, what are the shareholders' roles within the company? We're going to deal with several scenarios, but one of the first questions you have to ask yourself is, what are the shareholders' roles? Job descriptions can be set out in the shareholders agreement and should be reviewed and approved by all, and where there's an overlap, there needs to be a mechanism for possible conflict. But if you can't identify your roles and roles of others within the business, that usually leads to discussion of the overall responsibility within the firm.